A single admission can rewire a trial when the file already holds surveillance logs, witness statements, and a potential death sentence. The question is what the law lets jurors do with those words and how the rest of the evidence shapes their meaning. The thing about this case is the framework was heavy from the start. Nebraska prosecutors charged first-degree murder under Nebraska Revised Statutes, Section 28-303, which requires premeditated intent and abandonment of human remains per section, 28-1291, exposing capital punishment under the state's aggravated murder provisions. Trail's ritualistic claims and coercive tinder setup breached these by evidencing deliberate luring and concealment to evade detection. That pairing signals intent on one count and post-offense conduct on the other. It also signals capital exposure. With that, every procedural step tightens. The court schedules advisements, the judge confirms counsel. Discovery moves under deadlines that preserve due process because mistakes at this level echo on appeal. Let's break down the path to trial. The record shows appointments of counsel, bond decisions tied to risk and the gravity of the charge, and a docket that moves through arraignment to pretrial hearings. In capital-eligible cases, the court polices timetables and resources with special care. If a defendant hints at pro se elements, speaking on their own or filing personal motions, the judge can allow it with standby counsel, so the right to self-representation does not wreck trial integrity. Every move is logged so the transcript survives scrutiny. Tension built because Trail's narratives kept shifting. Early statements floated an accident. Other versions leaned on ritual claims. He told investigators that about half of what he says is garbage. He publicly claimed he was a vampire with special powers, and that recruits would need to kill to fully become witches. He also asserted that he and Bailey Boswell knew Loof months before the Tinder date, and that he was trying to bring her back into their group with offers of financial help. When those versions meet the courtroom, the judge filters them through the rules. Statements outside oath and outside the stand do not carry the same weight. Inside the courtroom, under oath, the calculus changes. Speaking of evidence, the state's mosaic was broad. Surveillance placed movements before and after the crime. Witnesses described control, planning, and references to a so-called covenant. Prosecutors presented items they said showed preparation and intent. Each piece stood on its own foundation. Who saw what, how it was documented, and whether the chain of custody held. None of those witnesses claimed to be present at the moment of death. That matters. Without an eyewitness to the act, the jury audits corroboration against the defendant's words.